Good morning, everyone. Court does call the case of Orchard Grove versus Robert Holliday.
Good morning, Judge. Jen Wilburn, P83143 for plaintiff.
Good morning. Mr. Holliday?
Yeah.
All right. You're here. All right. What is plaintiff's claim in this case?
This is a non-payment of rent case, Your Honor. There's an outstanding rental balance, $1,567.93, plus court costs, $193 for a total of $1,760.93.
And sir, how are you intending on getting that paid?
My wife and I'm sorry, I'm a little intimidated by this. Yes, we should have the money by the end of the month, hopefully.
By the end of the month? All right. Have you tried to work something out with the landlord on that, sir?
They didn't really give me an opportunity to kind of work any kind of arrangement out. It's simply get us the money or we're going to court. I could tell you more about the circumstances that make it a little bit more understandable.
Well, I don't know that I need to know that at this point in time. What I'll do is I'll give you 1 week adjournment. See if you can work something. It's going to be 2 weeks. Oh, that's right. I happen to be out for other reasons on the 20th. So I'd have to go 2 weeks out, counsel.
Understood, Judge.
On the case, on his adjournment. So I will adjourn this matter. And sir, in the interim, see if you can work something out with the landlord. If not, then we'll deal with it on the 27th. I'll adjourn this matter June 27th, 2025 at 3 p.m.
At first glance, this may seem like the judge is simply delaying the inevitable, but that's not what's happening. Judge Simpson immediately narrows the case to the issue that legally matters most at this stage: whether the tenant can resolve the rent balance before the court has to decide possession. Notice that when Mr. Holliday begins explaining the personal circumstances behind the missed payments, the judge politely redirects the conversation. That's because an eviction hearing isn't primarily about whether someone has a sympathetic story. It's about whether the legal requirements for possession have been met and whether there's still an opportunity to cure the default. Another important detail is the judge encouraging both sides to negotiate outside the courtroom. Courts generally prefer voluntary resolutions when possible, because an agreement can save both parties additional costs and avoid a formal judgment. Did you notice that the judge also pointed the tenant toward rental assistance resources before ending the hearing? That shows the court isn't choosing sides. It's ensuring the tenant knows what options remain before the next appearance. The next hearing will likely depend less on explanations and more on whether meaningful progress has actually been made toward resolving the debt.
And sir, we played a video initially. If you need assistance, you should try to contact some of those numbers and see if somebody can help you out. All right?
Yes, I apologize. What was the date again?
June 27th at 3 p.m. That's an in-person hearing, sir.
An in-person hearing. Okay.
Yes, sir.
Thank you very much.
Okay. All right. Thank you.
Thank you, Judge. Have a good weekend.
Oh, you do the same.
Thank you.
Court does call the case of Beal Properties versus Lillian Martinez.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff. Your Honor, I believe we've submitted a proposed dismissal without prejudice for this case.
Oh, did you? Okay, I don't have it. This case has been dismissed. That is without prejudice. Court does call the case of Beal Properties versus Cozine Welch Jr.
Daniel Landman, appearing for the plaintiff.
They haven't signed in today, but were here yesterday.
Yeah.
Okay. Yeah, it doesn't help us today. They're not here. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Go ahead, sir.
Your Honor, this is a summary proceedings action based upon a rental arrearage. Based upon my client's books and records, the current rent to retain is $2,030. Costs are $175 for a grand total of $2,205. The proposed default judgment would reflect a writ date of June 23rd. To the best of my knowledge, this tenant is not incompetent, a minor, or a member of the military service. And to the best of my knowledge, this lease premises has been kept reasonably fit for the use intended during the lease term.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days. Beal Properties versus Brielle Roundtree.
Daniel Landman for the plaintiff.
Tree, they are not checked in. You may proceed, sir.
Thank you, Your Honor. Again, this is a non-payment action. Based upon my client's books and records, the current rent to retain is $1,774. Costs are $175 for a grand total of $1,949. The proposed judgment reflects a writ date of June 23rd. To the best of my knowledge, Ms. Roundtree is not incompetent, a minor, or a member of the military service. And to the best of my knowledge, this leased premises has been kept reasonably fit for the use intended during the lease term.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ issued 10 days. Beal Properties versus Mike Lucas.
Daniel Landman appearing for the plaintiff. Mr. Lucas is present, Your Honor.
Yes, he is. All right. Mr. Lucas, good morning.
Good morning, Your Honor.
What is plaintiff's claim in this case?
Your Honor, this is also a non-payment action. My client's records reflect a balance owed of $2,244 and costs of $175 for a grand total of $2,419.
All right. Mr. Lucas, how are you intending on getting that paid, sir?
Well, my lease here ends on June 25th, and I already informed them that I was leaving. But prior to this, they received non-payment because of the deplorable conditions I'm living in. And I had to pack my stuff up, start taking it out of here to a storage unit because I got pictures, Your Honor, of rats in the garbage. I went without hot water for 8 days because they didn't want.
All right. Mr. Lucas, are you going to move by that date? Because they're only looking for possession of the premises. Are you going to move by the 25th?
I'm out of here.
Okay, that doesn't end. Are you out now?
I'll be out on the 25th. I told them yesterday.
Okay. All right. That works. Here's what I'll do. My next date is the 27th. So I'm going to adjourn this to June 27th, 2025 at 3 p.m. And maybe at that time, the matter can be dismissed if you've vacated the premises and turned in the keys.
All right. What's the date? What's the date, Your Honor?
June 27th, 2 weeks from today, 3 p.m. If you're not out of the premises, that's an in-person proceeding, so you'll need to be here.
All right, I'll be out of here. Believe me, I'll be out of here before.
Okay. All right.
All right.
Thank you.
All right. Thank you.
Thank you, Your Honor. Have a great weekend.
You do the same, Mr. Lynn. James Convis versus Anna Teachworth.
Thank you, Your Honor. I'm asking for an eviction. I'm Jim Convis. I'm the owner.
Hold on.
Landlord.
Sir, state your name first of all, please.
James Convis.
All right. And your name, ma'am?
Anna Teachworth.
All right. It's a non-payment of rent case. What are you claiming is owed, sir?
Thank you, Your Honor. There may be more information here than you need, and I apologize for that, but I'm asking for an eviction order and a money judgment to be issued as soon as possible. To simplify this as much as possible, Anna has not paid any rent this year and hasn't even paid me back cash I loaned her last year. I have been telling Anna countless times this year that I have a court order to pay alimony to my ex-wife, and I am on a fixed income and cannot abide by that court order unless she starts paying rent. Many, many promises were made, but very, very, very few kept. No rent money has been made at all this year. Last year, she might have paid 2 months, and I was trying to work with her and some of her boyfriends so she could help.
Okay, sir, you are right. That is way too much information for right now.
Okay.
How much are you claiming is owed?
My demand letter is fine. It's $43.50. I don't expect to ever collect that, but that's fine.
Did you send a notice to quit, sir?
I did.
Her? All right, there it is. $43.50. All right. Ma'am, first of all, do you believe that you owe that money? And if you do, when do you intend on paying?
I do not owe the entire amount. I've asked for a detailed breakdown of what he claims that I owe $43.50 for, and I'm working with the Washtenaw County Housing and Michigan Department of Health and Human Services.
Okay, so you've applied to both of those?
I've applied to Washtenaw. I am in process of applying today to Michigan Department of Health and
All
Human
right,
Services.
I got you. Okay. So here's what you need to do. Since you're applying for some type of assistance to pay, you would need to file in your packet. There was a rental assistance form.
Mhm.
You need to fill that form out. You need to put, when you do the DHHS, you need to put the tracking number on that. You need to file that with the court by next Wednesday.
Okay.
Okay. You say you contacted Hawk or Housing Access for Washtenaw County or SOS?
I did. I have to call and call back and schedule an intake now that I have the official paperwork.
Okay, so have you scheduled an intake with them?
Not at this time, no. I will call them today as well.
You need to get on that. I will adjourn this matter out. My next available date is the 27th. I'll adjourn it out to June 27th, 2025 at 12 noon. Folks, that is an in-person proceeding. Both of you need to be here.
Thank you, Your Honor.
All right? All right. Thank you. Court does call the case of Arbor Woods versus Tanisha Booker.
Good morning, Your Honor. Rachel Dornbush, Palace Law on behalf of the plaintiff. And Your Honor, this one's actually a dismissal.
I don't.
Can you hear me now, Judge?
Yes, we can hear you. It was a problem on our end.
Okay.
All right. Yes, go ahead.
This one's actually a dismissal, Your Honor.
It is? Okay. Case is dismissed. That's without prejudice. Arbor Woods versus Jennifer Carroll and Linda Carroll.
I'm here.
Okay, I need a camera, please. All right. What is
Okay, hold
plaintiff's, all right. What is plaintiff's claim in this case?
With costs, Your Honor, $1,737.50.
All right. Ms. Carroll, how are you intending on getting that paid?
I can pay $700 today. I do have an SER in to try and get help with the rest.
All right. So you're going to pay $700 today?
Actually, can I do it tomorrow? I'm not sure. Maybe I'm going to get a money order until.
Okay. That you'll do that. And then you have an SER in?
Yes.
Okay. You'll need in your packet, or you can use the QR code that's on the screen. There's a form called a rental assistance form. You'll need to fill that out, put the tracking number on there, and file it with the court by this Wednesday.
Okay.
Okay, you need to do that. I do not have next week, so I will adjourn this then to June 27th, 2025 at 1 p.m. That is an in-person proceeding, ma'am.
Okay.
All right, thank you.
Thank you.
Arbor Woods versus Mary Clark. Mary Clark? Not present? Yes, you may raise your right hand, Ms. Dornbush. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, for the record, Rachel Dornbush, Palace Law on behalf of the plaintiff. Rent to retain is $808.50. Costs are $186 for a total due of $994.50. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Arbor Woods versus Alyssa Cole. She is, okay, Ms. Cole is here. All right. And what is plaintiff's claim in this case?
With cost, Your Honor, $2,995.10.
And Ms. Cole, how are you intending on getting that paid?
I'm back to work. I was off work for like 2 months. And there has been some issues with my back pay. I'm still going through the stuff with that at my job, but I am back working full time. And my next full check will be on the 27th. I plan on paying as much as possible, which will probably be around at least $2,000. I did put in something. I applied to 2 places. One place I got denied. And then the other place, they said I needed an actual eviction notice, that they couldn't help me out right now because I didn't have an eviction notice. Like I said, I am.
So who told you that?
The DHS.
The last one.
The DHS.
Okay, that's not correct. If it was DHS.
It is.
I
have the letter that they sent, and they said it was denied because I didn't have an actual eviction notice.
Did you give them your paperwork?
I sent them the court documents. Yes, that was sent to my house, and they said that it wasn't an actual eviction notice.
Okay. Is Amy here?
Yes, she is.
Okay.
Good morning, Your Honor.
Good morning. I was trying to recall at the meeting, I think they were, when we ran into this, they were instructing individuals to go and to ask to speak to a supervisor, if I'm not mistaken.
I'd be happy to meet with her real quick and just try to clarify. And get
Okay. All right. We'll do that. So what I'll indicate, is that you're going to pay $2,000 by the 27th. Is that correct, ma'am?
Correct.
Can you pay that? What's the time on that? Time for 1? Can you get that paid, say, before noon on the 27th?
Yes.
You can? Okay, great. Then I'll indicate that, and then I'm going to adjourn this matter to the June 27th, 2025 at 1 p.m. Okay, get that paid before noon on that date. All right?
Okay.
The other thing is that if you resubmit your SER, there's the form that's in your packet, the rental assistance form. You'll need to fill that out, put the tracking number on, and file that with the court by Wednesday.
Gotcha.
Okay?
Okay.
All right.
All right. Thank you.
Yes, and ma'am?
Yes.
Ms. Cole?
Yes.
Hold on the line. We're going to put you into a breakout room with our court liaison officer to try to clarify that issue for you, okay?
Okay. Thank you.
Thank you. Arbor Woods versus Alexandra Figueroa Mejia. Figueroa Mejia. They are not here. Ms. Dornbush, you may proceed.
Thank you, Your Honor. There's rent to retain of $4,406.54, costs of $186, for a total due of $4,592.54, and we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issued in 10 days. Arbor Woods versus Christopher Finkowitz. Christopher Finkowitz, they have not checked in. You may proceed.
Thank you, Your Honor. It looks like at this point, Mr. Finkowitz only owes a portion of the court costs, so the total balance due is $132.21. We'd ask for a default possession only judgment with writ to issue after 10 days, and in light of that balance, I assume the court will indicate no writ without hearing.
That is correct. Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days, no writ without a hearing. Arbor Woods versus Torrance Johnson. Torrance Johnson, you're not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,628.47, cost of $186, for a total due of $1,814.47, and we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Arbor Woods versus David McLeod. David McLeod, they've not checked in. You may proceed.
Thank you. There's rent to retain of $788, cost of $186, for a total due of $974. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Arbor Woods versus Tyrone Miller.
That's a dismissal, Your Honor.
That's a dismissal. That case is dismissed. That's without prejudice. Court calls the case of Arbor Woods versus David Pitchford Jr. and Helen Cummings. Pitchford, Cummings.
I'm here. I'm trying to get.
I'm sorry.
I'm trying to get my camera on. Okay. Hello.
Oh, there you are. Okay. All right. You're Miss Cummings?
Yes, sir.
All right. What is plaintiff's claim in this case?
No, Your Honor, the remaining balance due is $296.83. It's about $55 in rent, and then the court costs of $242.
Okay, so $296.83.
That's correct.
All right. All right, Ms. Cummings.
Yes, sir.
When are you going to get that paid?
Well, this is my case, Your Honor. They charged me late fees after telling me that they would dismiss my late fees. Then I end up with court costs. Now I'm on a fixed income. I pay my rent on time every month. I own my modular. And this time I ran into an error with the computer system. We're just now getting a site manager here. So no one's there at the office to help us with our problem. I've been here for 10 years. I was told to pay online. And the reason to have to pay online is so we don't have to pay a lot of court charges because they log it in late. But now, here I am trying to pay online and it keeps coming up error. I go to the office. We don't have a site manager. I finally get someone. They tell me they're going to dismiss the charges. And then they didn't. I'm on a fixed income. I can't pay that. By the time I went in to pay what I thought they told me to pay, which was $7.50, it was at $11.77.17. I didn't have that. And you overcharge.
Okay, Ms. Cummings. Ms. Cummings?
Yes.
When you say you fell behind in your rent, they filed a case back in May.
I paid them in May.
Your Honor, if I may, I'm reviewing the ledger, and it does look like my client did credit the May late fee of $55, leaving a balance due of $739.83, but that balance wasn't paid until May 21st, and at that point, this case had already been initiated. So there's the court cost of they're on the ledger for $244.15, but I think they're actually $242. So our balance makes that adjustment. It reduces it by $2.15. And then I do show the $750 paid on May 21st. There was an additional late fee on May 21st of $30. June charges hit, and there was a payment of $790.74. Looks like that was paid on June 7th. And so there was a June late fee of $55 that was charged as well on the rollover balance.
Got it.
And I'm on a fixed income. I can't pay.
Okay. All right, Ms. Cummings. Ms. Cummings.
Yeah.
If you had to get this paid, how do you think you can get it paid?
$1 down, $1 a month. I'm on a straight up fixed income, Judge Simmons. I don't have extra money.
Ma'am, Ms. Cummings.
Yes.
Ms. Cummings.
Yes.
I hear you.
Okay.
Okay. The reason I was asking the questions that I was asking is because if I didn't think that you owed it, I would say so. But it sounds like it's owed. So the question becomes, and that the case was properly initiated. So then the question becomes, for me, as to how you can get this paid.
This exchange is one of the most legally significant moments in the hearing because Judge Simpson separates emotion from legal liability. Throughout her explanation, Ms. Cummings raises concerns about computer errors, staffing problems, waived late fees, and the financial strain of living on a fixed income. Those circumstances certainly explain why the dispute escalated, but they don't automatically eliminate the remaining legal obligation if the landlord's accounting ultimately supports the balance. That's why the judge first determines whether the debt itself appears valid before discussing payment options. Notice something else that's easy to miss. Rather than immediately entering judgment, the judge invites the landlord's attorney to explore a payment plan with the client. That reflects a practical courtroom strategy. Once liability appears established, the court often shifts toward finding a workable resolution that protects the landlord's right to payment while giving the tenant a realistic opportunity to comply. Did you catch how the attorney openly acknowledged the limits of her authority and promised to consult the client instead of making commitments she couldn't legally honor? That kind of candor strengthens credibility with the court and often encourages the judge to grant additional time rather than forcing an immediate outcome.
I have to pay a little bit at a time. I don't have money.
Pardon?
Your Honor, if the court wants to set this over for the next date, I can certainly talk to my client and see if they're able to work out any sort of payment plan with Ms. Cummings with respect to the balance. I don't have any authority to do that today, but I can certainly inquire with my client.
All right. You understand that, Ms. Cummings?
I sure do.
All right. So here's what I'm going to do, Ms. Cummings, is I'm going to adjourn this to June 27th, 2025 at 1 p.m. Okay.
Okay.
In the interim, Ms. Dornbush is going to talk to her client, see if there can be a payment plan to try to make this manageable for you. It's just that you ended up with the court cost, and that's really what the problem is here. So we could figure this out. Don't lose hope. We'll get it done. Okay.
Okay.
All right. We'll see you. That's an in-person.
I got a
hearing on that.
question.
Yes,
do
ma'am.
they keep adding late charges when you don't pay. So does it stop here?
Okay. All right, Ms. Cummings. Ms.
Yes.
Cummings,
Yes.
hang on. We'll figure that piece out for any late fees that come later in the month. But let's try to figure out if this were the amount, how we're going to get that paid. And let's try to work out a payment plan, and then we'll figure out the late fee part after that. Okay. So let's take it one step at a time. All right.
All right. Okay.
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 So I'll set it out on the 27th at 1 p.m. That's an in-person hearing. Okay, Ms. Cummings?
I'll be here. I'll be there.
All right. Thank you, ma'am.
Thank you.
Arbor Woods versus Heather Randall.
I'm here.
Oh, there she is. All right. All right. What is the plaintiff's claim in this case?
With costs, Your Honor, $3,889.75.
Okay, Ms. Randall, how are you intending on getting that paid?
I just got back to work. I've been in the hospital. I had surgery and then had to subsequently go back in. So I'm back to work starting Monday full time. So 2 weeks from then, I can make a payment of at least $1,200, and then I'll have to see, the dates on the rest so I can figure out. I do get paid weekly.
Okay. All right. So hold on there for a moment.
Sure.
When's the next time you think you can make a payment of at least $1,200?
Next Friday.
On the 20th?
Yes.
Okay.
Well, it would be
So-
Saturday.
Right. Gotcha. So and by the 27th, can you make another payment or no? If
Yes.
you get paid weekly.
Yes,
All
I
right.
get paid
and
weekly.
How much would that be, you think?
600.
600? All right.
Yes.
Okay. So here's what I'll do. Have you reached out for assistance at all, ma'am?
Like I said, I just got out of the hospital, and I just got all of this paperwork. So I will be filing for a state emergency relief and looking into other things, looking into other
Okay.
avenues.
All right, let's do this then. You look at making those payments. I will adjourn this to June 27th, 2025 at 1 p.m. And then what I'm going to do, did you see the video and do you have the numbers and things like that, or?
Yes, I saw the video.
Okay, so what we'll do is let me also, since you just got out, and to try to make sure things stay on track, you still make those payments. I'm going to put you into a breakout room with our court liaison officer.
Okay.
And talk about what might be available for you. Okay.
Okay. Thank you so much.
Try to get you back on track.
Thank you.
Okay. All right. We'll see you in a couple weeks. Thank you.
Thank you.
Court calls the case of Arbor Woods versus. You're going to put her in the thing. Yeah. Okay. Court calls the case of Arbor Woods versus Erwin. Ulrin. Excuse me, Robertson.
And that's a dismissal, Your Honor.
That's a dismissal. You made me stumble over the name, and then. Okay, that's okay.
Sorry.
All right, that case is dismissed without prejudice. Arbor Woods versus Damon Stafford, and also Bansari Polk. Stafford, Polk, not here. You may proceed.
Thank you, Your Honor. Mr. Stafford did reach out to our office this morning, Your Honor. He indicated that he thought court was yesterday and that he is traveling today. He indicated he was going to try to get onto the Zoom call today, but he didn't specifically know when his plane was departing or if that would interfere. I let him know that if he wasn't able to sign onto Zoom, I'd have to request the default judgment. He indicated, Your Honor, his intent to have everything paid on June 25th. The statutory 10-day period is June 23rd, and I let him know that. And I did also let him know that he could reach out to Arbor Woods directly to see if they would hold off on seeking the writ until after June 25th.
Okay.
So for that, I do have to request the default judgment, and there is rent to retain of $1,483.73, costs of $242 for a total of $1,725.73.
All right. what I'm going to do in this case, and thank you for informing the court in your candor, I'm going to grant a judgment for possession to the plaintiff with the redemption amount in the amount requested. I will do this since they reached out and he indicated a specific date, and I don't think it's going to cause any harm. A writ to issue the 25th. I'll do it that way, and I realize I'm doing that over the objection of plaintiff.
Thank you, Your Honor.
Court does call the case of Arbor Woods versus Carol Toronto and Judith Wells.
So here. Oh, I'm here.
Okay, hello, Ms. Wells. All right. What is plaintiff's claim?
With cost, Your Honor, $3,481.44.
All right. Ms. Wells?
Your Honor, if I would be allowed to speak for Miss Welts, I'm Carol Taranto's daughter.
I'm
And,
sorry?
I'm Allison Kirby. Sorry. I was wondering if I would be allowed to speak for Miss Welts and Carol Taranto. I'm their daughter and granddaughter, respectively.
Okay. So you're the daughter and
I'm Carol
granddaughter.
Taranto's daughter and Judy Welts' granddaughter. Yes.
Okay. Okay. Normally I'll let you go ahead. All right. What did you want to say?
Thank you. I really appreciate that, Your Honor. I would like to request a motion for continuance. If possible, Carol Taranto is the primary provider and therefore has more of an idea of the finances, but she's currently in the hospital. So I was hoping if we could push this case until she was released.
All right. So let me ask this before I do anything. Is there any amount that can be paid within the next couple weeks? Do you know?
I don't currently know the state of her finances, unless that was something that I would be paying. But yes, that I'm unaware of that. I'm sorry.
All right, Ms. Wells, you don't have any idea as to whether something can be paid or not?
No, I don't know, Your Honor.
Okay. Here's what I'll do. I will adjourn the matter to the 27th, 2025 at 1 p.m. That's an in-person proceeding. Are they going to potentially be in need of any assistance, ma'am, do you think, or?
I'm sorry, I'm sitting with Judith here. We are currently having a very hard time.
Who are you?
I'm sorry.
Sorry.
I'm so sorry. I'm just helping Judith in person. My name is Anna. I'm one of her granddaughters.
Okay, so I got granddaughters and all over the place here. All right, go ahead.
Yeah, sorry. One has been coordinating getting the hospital to like fax documents over, I guess, and then I'm the one that is in person with Judith.
Okay.
But I am seeking resources for her for all of the above, like any type of state assistance, anything that we can be directed to, we would appreciate.
All right. So here's if they seek assistance through DHHS or anything along those lines, or any other type of assistance, in the packet, there is what's called the rental assistance form, the packet that was served on them. That would need to be filled out with, and if it's DHHS or a state emergency relief, there's a tracking number that would have to be put on that form. All right. If there's any other type of assistance, that would have to be listed out. And then that form needs to be filed with the court by Wednesday. Okay.
Oh, I'm sorry.
Okay, I got it, Grandma.
Okay.
You got that? Okay. And here's what I will do also. She's just going to be busy today. Let me have the two things here. It will put you in with my court liaison officer, and they may be able to apprise you of other assistance that might be available. Okay?
Yep.
Thank you so much, Your Honor.
Thank you. So that's on the 27th. That's an in-person hearing. All right. But we'll go from there on that. All right.
Thank you,
Yes,
Your
hold
Honor.
on. Pardon? Who's the last name?
The one with Judith Wells, the granddaughter.
Oh, the granddaughter that's with Judith Wells. For our records, we need your last name.
Jones.
I told you it was really easy. No, I'm kidding. All right. All right. Well, so you guys hang on the line. We'll put you into a breakout room with Amy, and she'll be able to discuss some things with you. Okay?
Yes, thank you so much, Your Honor.
Yes.
Thank you. Arbor Woods versus Roy Williams and Terry Williams. Roy or Terry Williams, not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $785.24. Cost of $242 for a total due of $1,027.27. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested. Writ to issue 10 days. Northfield Estates versus Emma Lowe.
Hello.
Hello, Miss Lowe. How are you?
I'm okay. How are you?
I think I'm okay. All right.
I feel
And
excited.
what
I've
is-
seen you on court cam before. I feel like I'm talking to a celebrity.
Yes, Miss Dornbush is a celebrity. All right. All right. What is plaintiff's claim in this case?
With cost, Your Honor, $1,438.65.
All right. All right. Ms. Lowe, how are you intending on getting that paid?
I just got my first paycheck at my new job today, so I was gonna pay 800 of that, and then before my next paycheck should be able to come up with the rest of that balance.
Okay, so you're going to pay 800 today?
Yep.
Okay. And
Your
then
Honor,
you're
just to clarify, my client reported that Miss Lowe already paid 800 today. So is she going to pay another 800 then?
Correct. This was my first paycheck at my new job. I lost 2 jobs in 3 months, but I have 2 new jobs. So I'm hustling, trying to get that money paid.
Gotcha. Okay, I just wanted to clarify, Miss Lowe, because I knew you had made the one. So
okay. So you already paid the 800.
I paid an 800 this morning. I have another 800 coming tonight.
Okay, so there's going to be a total of 1,600 that's paid.
By Monday, when they get the after hours.
Okay. All right. So if you do that, what will likely happen, I'll give you an adjourn date of the 27th, 2025 at 1 p.m. But that will look like that will take care of everything. And so that's paid, the case would be dismissed, or am I wrong?
nope, the $1,438.65, Your Honor, already takes into account the $800 payment made this morning.
I got you. That makes sense. I'm sorry. Okay. So you're going to pay the 800. I'll adjourn it out to the 27th at 1 p.m.
If I have that balance.
Make that. Okay. And so when's your next check?
It's 2 weeks from today.
So on the 27th?
Yep.
Okay. So do you think you can get something paid if it's going to be the balance before, say, noon on that day?
If it's paid total by balance, does that mean I don't have to show up in person?
What, you don't want to be there in the presence of a celebrity?
I do, but I just don't want to miss any more work. Just starting at my new job.
Ma'am, if everything gets paid prior to the court date, they would dismiss it.
Oh, thank goodness. Thank you so much. Yes, that will be done.
So, all right, then I'll set it on the 27th at 1 o'clock. Miss Lowe, you have a great weekend.
Thank you so much. You too.
All right. Take care.
Bye.
All right. That's all I have for you, Ms. Dornbush.
I agree, Your Honor. There are a couple people, though, signed into Zoom.
I
don't
know.
If they're Arbor Woods tenants. They might be dismissals. But before I signed off, I just wanted to make sure I wasn't missing anything.
And they all disappeared except the phone, but I don't have the number. There is an individual who has called in. I don't have the number up anymore.
Hi. Hello.
Hello, what's your name?
Kimberly Slayton.
That one is a dismissal, Your Honor.
That was a dismissal? Okay. Your case has been dismissed, ma'am.
Okay, thank you. Have a good morning.
All right, you too. Thank you.
Thank you.
Looking back across today's docket, one theme stands out above everything else. Judge Simpson consistently distinguished between tenants who were simply facing financial hardship and tenants who failed to participate in the legal process. Throughout these hearings, the court repeatedly gave people additional time when they demonstrated a realistic plan, sought rental assistance, communicated honestly, or showed a willingness to cooperate. On the other hand, when parties failed to appear or offered no evidence to support their position, default judgments followed because the court had little choice under the applicable procedures. Another detail many viewers may have overlooked is that the judge never treated an eviction case as just a question of unpaid rent. He repeatedly examined whether assistance had been requested, whether payment deadlines were realistic, whether both sides had communicated in good faith, and whether a negotiated solution remained possible before entering more serious orders. That balanced approach protects the landlord's legal rights while also giving tenants every reasonable opportunity to preserve their housing when the facts support additional time. So, what do you think was the biggest lesson from today's session? Was it the importance of appearing in court, documenting financial hardship, or communicating with the landlord before the case reaches a judge? Let us know your thoughts below. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.